to call the City of Fairhope Board of Adjustment meeting for June 16th, 2025 to order. Our first order of business is the approval of the minutes. Do we have a motion to accept the minutes?
I
You
make a
may-
motion
yes,
to
please.
accept.
Yes. Do we have a second?
I second.
All in favor?
Can't hear.
Aye. Before we get started, I'd like to introduce our board to you. Donna, I'll let you go first.
Donna Cook.
Anil Vera,
What?
you got to introduce yourself.
Oh, I'm sorry. I'm out of it. I've been waiting in traffic lines. Kathy Slagle.
Frank Lamia.
All right. So our consideration is a BOA 25.05. It's a public hearing to consider the request of the owners, Robert and Melanie Roberts, for a 20.7-foot front setback variance and a 3.14-inch setback variance on the property zoned R2. The property is located at 657 North Mobile Street.
Thank you, Mr. Chairman. Before I get started on the presentation, just wanted to, one bit of housekeeping. This is a variance request. We have 4 members tonight. So to grant a variance, all 4 have to vote in the affirmative to grant the variance. So have to have 4 votes to grant that. So as we work our way through the comments and reviews, just want to point that out as we get close to the end. This property is zoned R2. The zoning map for the area is on the left, so you can see that all the properties surrounding this are zoned R2. On the right is an aerial photo taken from our Baldwin County parcel viewer. The subject property is highlighted in yellow. I'm going to kind of start with the current conditions of what we see here and try to make a diagram to explain this. Right now, what we're seeing in the yellow is the buildable area, so the area within setbacks for the principal structure. As you can see, the house was built, and we'll get to why and how and all those good things, but the house was built in the front setback. So the lighter blue is the house, the darker blue is the porch. Originally permitted in 2022, there's been a lull through construction. There was a change in contractors, and you can see some of that in the narrative and the explanation of, I think, what Mr. and Mrs. Roberts have went through that area. In January 7th, there was a survey submitted that brought these setbacks to light from our perspective. So they are here asking for a variance for the amount that exists in the setbacks, as well as what you'll see, a proposed covered walkway on the side setback. Just to explain the 2 variances there, this is as well as we can do with some drone shots to explain the kind of rough approximate front setback, and you've got to imagine that line is existing under the house. The existing building per the supplied survey is 14.33 feet from the property line, where the setback is 35 feet. So the difference there of 20.7 feet is where the request for the variance is for. I do think it's important to just look at the approximately 5 feet of that is the house. The rest is the porch area. While we're on this slide, a little bit unusual for just unless you're looking at a legal document, a parcel record. I want to explain where the property line comes from. The image on the top of the screen, the houses atop the bluff. Some have little remnant parcels or recorded parcels down near the bluff, but there is a parkland and unimproved right-of-way between those. So that's roughly shown. That's not a legal document, just trying to show that overlaid on the aerial so you can see it. and the parkland becomes the property line, which is where the setback is from. On the side setback request, I've got a few images here. The proposed, and the first one kind of really shows what's there. There is a proposed walkway. It's been framed. The house itself is not in the side setback. So the middle picture, if you look at kind of the bolder blue line, that does not lie within the setback. And then the last one kind of shows, if you take a look at the garage in the back, that is 5 foot off the property line. It meets the setbacks for an accessory structure. So the covered walkway should be 10 feet off the property line. So that's kind of the difference of where the request is coming from for the 3.4 feet to cover that walkway and allow that to be in the side setback instead of in the principal building area. Just to kind of go over real quick, I'm not going to read all these. We'll read them as we kind of go through, but we do have certain review criteria for a variance. Those 4 items are listed on the screen, and I'm just going to step through each one and kind of give our commentary or review. The first one is that there are extraordinary and exceptional conditions pertaining to the particular piece of property in question because of its size, shape, or topography. So this lot in and of itself is shorter than the standard for R2. 75 feet wide is required. This is a 6-foot lot. That comes up quite a bit in front of this board. That is the standard lot size of most of the lots within the area. That is the fruit and nut. That is most of the things that were platted in 1911 and when the zoning ordinance came into place in the early 50s. It made those non-conforming, but we've accepted those. There's even some guidance on non-conforming lots and what extras they have for height and width when that is applicable. It's not applicable to this site. The buildable area, minimum building area of an R2 lot is 10,500 square feet. This lot has 19,200 square feet, so approximately more than is required there. So, while we do understand it's a non-conforming lot, there's really nothing extraordinary or exceptional about that. There is, and I'll show the replat. I'm going to reference lots 4A and 4B. In between, there is a bluff, and that is topography, but that lies within the right-of-way or within the parkland, not really affecting the buildable area at the top of the bluff. It's relatively flat, and when the replat was done, as you'll see, that was kind of, is there enough room to build on the top of the bluff? The next review criteria is the application for this ordinance to the particular piece of property would create an unnecessary hardship. And in our zoning ordinance, we even say personal financial hardship is not a justification for a variance. So as we said, when the Palisano Place replat was recorded in 2021, and that's the replat that created this property and the setbacks that we're seeing today, careful consideration was given to what is buildable. It was created there in part to kind of combine the lots, remove an old lot line, and to be able to utilize those as a bayfront lot. So the garage is in the rear on the street side, and houses similar to the adjacent houses have a bayfront view. There was a stall in communication or in construction for a year, and we do agree that there was considerable challenges with the contractor. That is, as you see in the packet, there's other cases outside of this room to be tried, but those are not really for the zoning ordinance to determine. And as we say here, the personal financial hardship is not a reason to grant a variance, or it's not a justification for an unnecessary hardship. I think we've talked about those a few times in this room under these conditions. The third criteria is such conditions are peculiar to the particular piece of property involved. And in our like I said, because of that room, if this lot was on the bluff and that was a limiting factor, that would give a reason for a variance. Hopefully, we would do that before something is built, and be able to review that, but we don't see anything in the buildable area for this to grant a variance alone. And then the fourth criteria, relief if granted would not cause substantial detriment to the public good and impair the purpose or intent of this ordinance, provided, however, that no variance may be granted for a use of land or building or structure that is prohibited by this ordinance. So there was a few proposals, and they're somewhat practical in thinking, but as we apply it to the ordinance, we kind of want to go through those. There was an existing house on the property. I believe it actually extended over the lot line, and that was demolished. And what our zoning ordinance says about those non-conforming structures is when it's not intentionally damaged, storms, I'm going to not read this language, but if a storm or natural disaster damages a building, an applicant has 1 year to come into the city and repair those, but that's not the case within this situation. So when that happens, everything comes into compliance. Our rules are pretty clear on that. There's no, and basically what that means, you can't tear down a house and use the old setbacks, the non-conforming setbacks. If the old house was built into a setback, once it comes down, you have to meet the ordinances of our time, or the current ordinances. Kind of continuing that review, it was also stated the house, and you can kind of see a mark on the subject property, is in line with the current locations of homes and the homes to the north and the south. We just overlaid the same map, and the yellow line kind of represents the front building line of the buildings adjacent. This is not a survey. It's the Baldwin County Parcel Viewer, and we do not necessarily disagree with that statement. They do align with the existing buildings. The kind of problem that we have with that is we've addressed that in our ordinance and what to do in those situations. And there is some relief granted, which I'll go into detail further in this review. There's a limit of what relief that is in our standard ordinances and certainly what we can approve administratively. There's an empty lot next to it. There is a house that seems to be meeting closely the setback just to the south of that. Some houses were built before the zoning ordinance. Some houses were granted an administrative variance when we used to have a different set of rules. If y'all remember the survey, everything within 200 feet, then you average the adjacent properties. Well, you can come up as close to as possible. 5 years ago, the zoning ordinance was amended to cap that at 5 feet maximum. So I'll touch base a little bit there. There may be some relief within that administrative variance. We did not get a survey of the adjacent property to the north, but guessing, that building is built somewhere around 20 feet. So if you average the 35-foot built lot and 20 feet, you would have a 27.5-foot average, which would grant 5 feet. So we would approve a 30-foot administrative variance if we received a survey of the property to the north that confirmed that was 20 feet or close, that would allow us to do that. And the other kind of thought there, that relief, if granted, should not cause substantial detriment to the public good. We skipped a few slides, so I'm going to reiterate that one. We did receive some concerns from neighboring property owners regarding sight lines and obstructed views. The image you see on the screen are kind of drone shots. The one on the left is facing north, the bay's on the right. At the end of the day, this one's pretty subjective. I can say, well, it's not blocking much of the view, but if I'm investing in the property, I have to acknowledge that there's a little bit of obstructive view here. So, at the end of the day, this one, we really didn't feel that this was enough to warrant to either deny or grant a variance for that particular, but we do acknowledge that there could be an obstruction of some side views when others come to build. Now, the covered walkway and the side setbacks, like I said, the house does not require a variance. The house is built within the principal building area. So, this is one of those, if the board concurs and the applicant would like to do this, certainly they can ask. The covered walkway in a side setback is a violation of the zoning ordinance, so would need a variance. We have allowed structures, arbors, things like that are open to the sky. We have allowed those, so if the applicant would like to use the structure there, put some plants in it and keep it uncovered, we wouldn't see a problem with that. We are kind of looking as a side note of limiting some of those structures, but that would be a zoning amendment. But with the cover over it, it would be in the side setback, and said a variance would be needed. And in conclusion of that, the staff is very sympathetic. That is a problem that we see a lot. I think in the last year or so, we've seen about 7 people in front of us that have had some kind of financial hardship that is real, but looking at the zoning ordinance and what our review criteria are, we do not feel that this is a necessary hardship due to the size, shape, and topography of the lot, and do have to recommend denial. I have some other slides here if we need them. Just for reference, these are the attachments you see if we need to come back and forth. I didn't put these in here, but they were appendix if you have any questions. We do have a couple of slide presentations. I believe Brad Hicks is representing the Roberts, so they would be kind of next in line, and I think we have some other comments when the public hearing is open. So I'll turn this over to the chair, and who would like to speak after this one?
All right.
Certainly the Roberts also have that opportunity as well.
All right, thank you. Would the applicant like to make a presentation?
Yes, thank you, Mr. Chairman.
Your name for the record, please.
I'm Brad Hicks. I'm with the law firm of Stone Crosby PC, and it's our honor to represent Bob and Melanie Roberts.
No?
I'll tell you what, we'll put it up for a second, and then we'll take it down so we're not out there in everybody's view.
We can just do this. I don't mind being,
You didn't have to include that in your slides, did you? Think we're going to include screens for everybody?
No, not this one. It's too big.
do we have that for the public record?
You can, yeah, absolutely. And I'll take it down in just a second if you have a chance to. Can y'all see?
Yeah.
So, again, Brad Hicks, our representative Roberts, thank you for listening to us today.
This means we'll need you at the microphone so they can hear.
Yeah, we're streaming online, so.
So we had a survey conducted of the entire Block 8 of the Volanta subdivision, which is where this property is. And every single house on that block is within the setback except for one. The house immediately north of our house, okay, the Roberts house is 14.3 feet away from the lot line. The house immediately north of ours is 11.6 feet from the lot line. So we're 3 feet behind them, and the house immediately north of that one is 12 feet from the boundary line. So, out of the 11 houses on Block 8, 10 of them are within the setback. One of them is 3.9 feet from the setback. Okay. This entire block is built to have houses on this line. It is the way that it is on the ground. Let me take this, yeah.
It's 3.9 feet from the property.
3.9 feet from the property line. Okay. Now, I've also got printouts of this slideshow in case y'all have any trouble reading these documents, because sometimes they don't show up nicely on PowerPoint.
Thank you.
So in addition to 10 out of the 11 houses on Block 8 being within the setbacks, every single lot on Block 8 is non-conforming because the lots are smaller than the minimum dimensions for R2. And every single lot on Block 8 is waterfront, but is bisected by this unopened right-of-way and a park that has no public access and that is maintained by the homeowners, not by the city. And even though the city admits these are waterfront lots, they are using the wrong lot line to measure the setback. And I'll touch on that later. The imposition of R2 zoning on a block that was in no way platted or created to comply with R2 zoning has created exceptional conditions pertaining to size and shape. The houses immediately north of the Roberts house, being almost 3 feet closer to the lot line than the Roberts house, has created conditions peculiar to their lot and a completely unnecessary hardship. The bisection of their lot by this unmaintained park and this unopened right-of-way have also created conditions peculiar to their lot and an unnecessary hardship. Granting the variance requested by the Roberts, which results in their house being almost 3 feet behind their neighbor's house, and which essentially keeps the status quo for all of Block 8, does not cause a substantial detriment to the public good. So how did we get to these exceptional conditions? So the first page, and you see I've numbered them on the bottom right corner, is the old 1914 plat of the Volanta subdivision. Again, no R2 zoning back then, no 35-foot setbacks. Each of these lots is barely 66 feet wide, almost 10 feet below the minimum requirements. And most of the lots on Block 8 are actually two small lots. It's only recently that Dr. Palisano combined lots, the lots that are now 4A and 5A. But their origin, just like every other lot on Block 8, is two small lots. So if you'll go to page 2, I've zoomed in there on Block 8. When you look closely at the lots created on the Volanta subdivision, you will see that none of the lots on Block 8 have a measured east to west length.
I don't know where you are.
Page 2 of the document I handed you.
Got it.
None of those lots contain a measurement from east to west. It's only the 66 feet in width. Consequently, in other words, you cannot tell from the plat how deep each of these lots is supposed to be. And the city is attempting to apply dimension standards to a platted lot that does not even show a measurement of depth. When you move past the lot lines for Block 8, and you see, of course, they're bisected by the park. And if you look closely at the park, you see that the park is non-uniform in size and does not contain any measurements showing the dimensions of the park. So by imposing R2 zoning standards to this plat that is over 100 years old, that contains small, unmeasured waterfront property, that bisects this property with an unmeasured park and an unopened right-of-way, the ordinance is creating exceptional conditions that will require variances for every house on the block, except for one. As I mentioned, the Roberts property, like everyone else on Block 8, goes all the way to the water. If you walk out there today, you will see piers, docks, and boathouses for the folks that own the houses on this Block 8. The Baldwin County Revenue Commissioner classifies this land use as waterfront improved. And the Planning Department admits that this is waterfront property. How do we know? Well, go to page 3. This is a screenshot from the staff report. The staff report is very clear that the setbacks at issue is the front setback. It says 20.7-foot front setback variance. Per the supplied survey, the existing building is 14.3 feet from the front property line. The front setback is 35 feet. Therefore, the variance request is for the difference of 20.7 feet. The applicant has not proposed any alterations to the building currently. If granted, the variance would result in a 14.3-foot front setback. So what does the zoning ordinance say? If you'll go to page 4. How does the zoning ordinance define a front lot line, where the lot line for a waterfront lot? In other words, where should we start our measurement for a setback? Article 9, Definitions and Interpretations, page 94 of the ordinance gives us the definition. Lot line, comma, front. For a corner lot or a through lot, the front lot line is essentially the lot line abutting the street. That is clearly not the case here. On a flag lot, the front lot line is measured from the interior lot line most parallel and nearest to the street. Again, that is not the case here. On a waterfront lot, which we all agree this is, the front lot line is, quote, the lot line abutting the water. So the city admits this is waterfront property. They plainly stated so in their report, that the front of the house faces the bay, not the street. And we all know that is the case with bay houses. The front is the waterfront side. In no way did they ever say the front lot line should be measured from the street. The lot line they have chosen to measure from, however, violates the terms of their ordinance, because the ordinance plainly states the front lot line on a waterfront lot is the lot line abutting the water. The lot line they have chosen as the starting point for their setback does not abut the water. So they're violating their own ordinance. This underscores the uniqueness, the peculiarity of this lot. It is a non-conforming, undersized waterfront lot that is bisected by an unmeasured park and an unopened right-of-way. But because it is waterfront, the front lot line, by definition, is the lot line abutting the water, not the line abutting the park. I cannot think of a single other property in Fairhope, besides these right here on Block 8 on this bluff, that shares this peculiarity. So the city has applied R2 zoning to property that they know doesn't comply with R2 requirements, but instead of creating a zoning classification that is appropriate for these old 100-year-old lots, the city has instantly created an entire street of exceptional size and shape conditions. Instead of creating a residential district that fits this area that existed before zoning, that means you guys are going to be forced to deal with variance after variance until it is fixed. So let's talk about a hardship. The application of R2 zoning to this particular piece of property does create an unnecessary hardship. Contrary to the staff's report, that hardship is not limited to personal financial hardship, although it is significant. The staff's report mentions neighbors complaining about view obstruction, but it never considers the Roberts perspective on that issue. If the Roberts house is constructed where it is completely in line, in fact behind, the neighbors' houses to the north. It's behind where the old house was prior to this one being constructed. It's almost 3 feet behind the houses to the north. It is the status quo. And if you look at the aerial photographs, which you saw earlier, provided in the staff report, for the record, Figure 7 and Figure 8 on page 6 of the report, you see that their house is essentially in line with everybody else's. Thus, leaving their house where it is does not affect anybody's view. It's just as close to the line as the old house. If, however, you do not grant a variance, the neighbor's house to the north will be almost 25 feet beyond the Roberts house. 25 feet. That is a view obstruction. Imagine if that happened to you, to your house. If you had to move it 25 feet back from the line that every other house was on your street. And I want you to keep in mind that the house immediately north of the Roberts was built in 2011. It's a new house. This is not some old house that existed long before zoning. And they added an outdoor fireplace towards the property line in 2016. Now, Hunter said there may have been some variance earlier. We didn't see any record of that, but the house is where it is, and it's 3 feet beyond our house. And I want to point out that we're not complaining about the house to the north. We think it's in the right spot. It's in line with everybody else's house. The Tarts live in that house. Mrs. Tart taught both of my children in school. I think their house is beautiful, and I think it's fine right where it is. And I think ours is fine right where it is. But if we are not granted a variance, our house will be 25 feet behind theirs, which will A, look ridiculous, and B, obstruct our view. That is a non-financial hardship. And remember that the house north of the Tarts is only 12 feet from the line. So if a variance is not granted, these houses will look like the white and black keys on a piano. There will be no uniformity, which the ordinance wants, thus making this 35-foot setback contrary to its goals. And let's also think about the hardship of having to move a house. Forget about the astronomical cost of moving a house that size. What about the safety? How can you ever trust the concrete slab on a bluff? How can you ever trust that the chimney won't crack and cause a chimney fire or topple over? This is an extremely heavy house, and moving it cannot help but create a safety issue. Now, these conditions are peculiar to the particular property. It's the same arguments that apply. The first house on the block, 12 feet. Next one, 11.6. As far as I've seen, although Hunter says different, no variance for either one. Allowed to be constructed by the city in 2011 and an addition in 2016. But then the Roberts house is 35 feet? Why us? Why do we get this peculiar honor? And what else is peculiar? Again, how many houses have an unused park and an unopened right-of-way sitting in front of them? And the park isn't even accessible by the city. It isn't maintained by the city. The owners of Block 8 cut the grass. This completely negates the purpose or benefit of such a large front setback. That's probably why every house on the street is within the setback. Because in all actuality, while it may be called a park, the grass is mowed by the property owners, and it functions like an extension of their yard. There is no road abutting the front of the house. which is normally what happens in R2. You build houses in R2, it's on a street, the front of the house is on the street, and so yes, it needs to be 35 feet back because you don't want to build houses on top of streets. That is not the case here. This is peculiar. This particular piece of property is different than other R2 houses going up around the city of Fairhope. And again, this is waterfront property. By definition, the ordinance says you measure it from where the lot line abuts the water, not from the park. This will not cause substantial detriment to the public. The staff recognized that in their report with a neutral recommendation. This house is further away from the boundary line than both of its northern neighbors. The house is simply the status quo for Block 8, and enforcing a 35-foot setback is what will create an oddity. Leaving the house where it is matches the neighbors, and it's the right thing to do. Now let me talk about the concept of this being a self-created hardship. So in its report, the staff says that it feels the current conditions are self-created hardships, even though they may be caused by an agent or agents. We take issue with that conclusion, and we'd like to present some information to show you why. When the Roberts architect submitted their first site plan, they did not show any setbacks on the drawing. The planning department did its job. It reviewed and verified the site plan. It caught that there was no setbacks on them, and it sent a message back to the architect. If you'll turn to page 5. So this is an email from Chris Ambrin with the Fairhope staff to the architects. The email says, a permit application is currently being reviewed and requires additional information. Please see comments below. If you go to the comments below, it says, please provide a document with all structures overlaid onto the survey/recorded plat. Also of note, all structures will need to be within required setbacks, front 35, rear 35, side 10. So, the architect got that email and created a new site plan. If you'll please go to page 6. This is a copy of the revised site plan that was uploaded into the CitizenServe system on July 8, 2022. I'll direct your attention to the left side where it shows a 35-foot setback. The architect measured that setback from the lot line abutting the bay, not the park. That revised site plan was uploaded for review by the planning department. If you go to page 7, so at this point in time, the planning department has received this new site plan. They have presumably reviewed it and verified it. Let me direct your attention to a screenshot, which is what this page 7 is, a screenshot of the CitizenServe website. You'll see a little arrow I've put there on it. It says, Planning Department Review, approved, period. View comments. That's July 12, 2022. So if you then click on the review comments, if you'll go to the next page, page 8, when you click on the review comments from the planning department on July 12, 2022, 4 days after the revised site plan was uploaded, the third bullet down says resolved. And if you go to page 9, I've zoomed in so you can actually read what it says. Every single comment says resolved. So, at this point in time, the architect and the builder who are relying on the city's review have no reason to believe that there is a problem with the site plan. The city said resolved, and the Roberts, who are relying on the city, the architect and the builder, have no reason to think there's a problem. 6 days later, if you'll flip to page 10, on November 18, 2022, the city emails the architect and says, "Permit application has been approved. Please see your permit card attached." Next page is the permit that was issued by the city. Now, go to the next page, which would be page, hold on, I got lost.
12.
14. Nope, excuse me. 13. I skipped a page in my notes here. So page 13, that is an email from the building department. No, excuse me. Page 13, the city has told the architect and the builder that the site plan comments were resolved. I'm sorry, go to page 12, not 13. Again, on page 12, this is about a month later, December 6, 2022. The planning department sends an email to the architect and the contractor stating, "Permit application has been approved. Please see your permit card attached." If you go to page 13, there's another permit. So the city has told the architect and the builder that the site plan comments were resolved, and it has twice issued a permit. They have no reason to believe there is something wrong. And why would they? The location of the house is consistent with the other houses on the street. It looks normal. No one standing there would think, "Oh, this is out of place. What's going on here?" Now, I assume some of you might be thinking, did the Roberts know about this? Were they trying to sneak something past the planning department? Were they trying to trick everybody so they could build a house where they were not supposed to? The answer to that question is clearly no. How do we know that? Because they self-reported. When they discovered this in 2025, they told on themselves. The city didn't know prior to them. If they had not self-reported, we probably wouldn't be here right now. None of the neighbors had complained before we self-reported because the house is in line with every other house. The Roberts were relying on the city who issued the permit, who said the site plan comments were resolved. Now, if you'll go to the next page, it's an email from the building department, Mr. Eric Cortinez, to the architect and the contractor, dated December 7, 2022, where he says at the bottom, "No plan revisions are required, but items listed on plans will be checked for compliance at inspection." All right, if you go to the next page, we have an email from Billy Nelson with the city, January 18, 2023. His comments say, "Provide a survey to verify as-built proper setbacks." Okay, that email was sent to the contractor. We do not believe the contractor ever uploaded a survey. But less than 1 month later, if you'll go to the next page, on February 13, 2023, again, less than 1 month later, an email is sent from Sean Bradley with the building department, which updates the inspection report and states, "Inspection is complete. Please see the report below." And if you go down the page, it says, "Inspection status is approved." This is the foundation. It's approved. And if you look further down, you note there are no comments by Mr. Bradley. None. No survey required. Mr. Bradley told the architect that the inspection was approved and no longer required an uploaded survey. So again, at this point, from February 13, 2023 forward, the architect and the builder have no reason to think that anything is unapproved or that anything is in the wrong place. As you know from the file, things turned ugly with the contractor, and they are currently suing him for other things. But it was not until after they sued him and had to get another builder to step into his place that they realized there might be a setback issue. And what did the Roberts do? Did they keep quiet and try to get away with it? Did they let sleeping dogs lie, hope nobody would notice? No, they self-reported. They went to the city and told them what they had found. So here we are. When you go back to the beginning of my presentation, when you look at the reality on the ground, when you see that the house to the north is 11.6 feet from the boundary line, and the house north of that is 12 feet from the boundary line, both of them closer than the Roberts, you can understand why nobody, not the building department, not the planning department, not the contractor, the architect, certainly not the Roberts, would think that something is wrong. But it's important to note that this was not all created by the Roberts agents. The city had a hand in this. The city knows this is a waterfront lot, but violates its own ordinance by not measuring from the lot line abutting the water. The city said that the setback comments were resolved. They said that to us. The city issued permits. The city approved the foundation without comments, leaving off any requirement to upload a survey. The Roberts should not be punished for turning themselves in and doing the right thing. The Roberts should not be punished for building a house that's almost 3 feet back from the boundary, more than their neighbors to the north. I want to close by reading a quote from the Variance Request Information Form, which is what the city gives to property owners when they're requesting a variance. And it's quoting state law, 115280 of the Code of Alabama. It says hardship. To authorize, this is what you're authorized to do under the law of Alabama. To authorize upon appeal in specific cases such variance from the terms of the zoning ordinance as will not be contrary to the public interest, where, owing to special conditions, a literal enforcement of the provision of the zoning ordinance will result in unnecessary hardship, and so that the spirit of the zoning ordinance shall be observed and substantial justice done. We submit to you that the special conditions we have outlined today show that a literal enforcement of the provisions of the zoning ordinance will result in an unnecessary hardship. We believe that granting this variance is within the spirit of the zoning ordinance and would serve justice, and we would ask that substantial justice be done. Thank you for your time.
Would the applicant like to come forward? State any?
Thank you. Yep, Bob Roberts, with my wife Melanie. Again, I just want to reiterate the reason we're standing here tonight, the reason we're all talking, the reason my fate is in your hands is because I called. I needed help. I needed to understand something. What I found out was we have a permit. What I found out is we've passed inspection. So I'm asking you, because I did the right thing, because that's the way I was raised, is to raise your hand and do the right thing, to expect other people to do the right thing. And so I'm asking you, I'm expecting you, please, to do the right thing tonight, to consider these things that Brad has pointed out. Pick any one of them, I think, brings enough to the situation that would warrant a variance. I want to thank you, too, for your service, civil service to this board as well. And I'm happy to answer any other questions. Thank you.
Mr. Roberts, what was it that you had told the city that you found, and how did you find the error? Is that concerning the lot line and the water line?
No, so I have a new builder. We figured out that the side setback with the walkway, which we can easily make uncovered, was not correct. And so with measuring everything, we had a question concerning the front setback towards the water. And so that's when I reached out to the city, but only to find out, going through the whole permitting process and downloading things from the portal, that I figure out that, well, this, yes, indeed, has been permitted. We have a revised site plan. It says resolved of all the issues that were brought up during the permitting process. And so these were things that I figured out. And then through this process, which started in November of 2024, I get to stop work 7 months later, which I'm not really sure why, but that's how we got there. It's a long-winded answer, but that's how we got there.
So your initial reason to get there was the side variance.
Yes, ma'am.
And then how was the front variance discovered? Or
We just started measuring. And so that's when I had a question of, well, where are we in this whole thing? And so, again, going back and starting to look at the site plan, the way that it was permitted, I figured out, well, the house is where it is permitted. But it was enough of a question for me to go down to the city and ask for clarification, because I wanted to make sure that I was doing this right. I wanted to be doing the right thing. And so that's what happened. And again, this wasn't a complaint by a neighbor, and this wasn't a failed inspection. Nobody knew that there was a situation, but there's not a situation, I guess is what I'm trying to say, because of the permit. But I wanted to make sure, so I called.
so at this time, you still thought it was the water line instead of a lot line?
Once I pulled up the site plan, yes, ma'am, I see that it is the water line. They'll need approved permit. That's what I needed clarification for.
Okay, thank you.
Open the public portion. Is there anybody from the public that would like to speak for or against it? State your name for the record.
Mr. Chairman, I'm Joe Thetford. I'm a lawyer at Chasen and Chasen. I represent Rick and Carrie Palisano, as well as their LLC, that they're the sole members of, Clover LLC. I have a binder here to preserve issues, and it includes a kind of a timeline and supporting documents that I'm going to go through. I've asked that this be made a part of the record tonight, and I've also got the presentation on the screen that we're going to go through. This first image here that I'm showing you is just to orient you to where my client's property is. See. Right here is the Palisano lot, the Roberts lot. Immediately to the south of that is a lot owned by Clover LLC that's undeveloped. And then 2 lots further south is the lot owned by the Palisanos. As an initial matter, before we get into everything, I just want to make sure everybody's on the same page that this is not a minor variance request. It's not a foot here or two because a contractor accidentally missed a corner or something. This is a 20.7-foot variance request on a 35-foot total setback. It's more than half. In addition, it's 3.4 feet on a 10-foot side setback. And so it's plain that this building was constructed without any regard to the applicable setbacks. Now, I'm not going to repeat the staff report. The staff report got it right. And the staff report focused on the factors that y'all are to consider with the variance. You heard a couple of things earlier, and one of them was, I think, a claim that it's the city's fault. the city can't object to it now, something to that effect. And then you also heard what I believe was some sort of a challenge to the zoning ordinance. This can't be zoned R2 because of the conditions of the lot. Those two things are inappropriate for consideration on a variance. So the consideration is whether they meet the factors for a variance. Staff analyzed those, and we agree with the staff report for the most part, and I'm not going to go back into that. But what I think is important, and you heard one version of the facts there, but the first thing, like I think y'all probably are thinking is, how did this happen, right? That was my first question. And I want to go through some of the documents and things that I've discovered to figure out how we got here. So this is a replat of the subdivision lots, okay? Clover LLC bought what was at one time 4 lots. It was 4 different lots right here. Lot 4A was 2 lots, Lot 5A was 2 lots. And then there was a portion of Block C that was not in lots. It was conveyed by meets and bounds. The Palisanos, through their LLC, Clover LLC, came up, worked with the city, and developed this replat. The house that was there was torn down. And so they developed lots 4A here and 4B. Now, I think y'all can all probably were asking yourself this question, and you're on the right track when you were thinking about it. These are separate lots. It's not one lot that's bisected by a park. They are separate lots. They're platted. This is a lot 4B. It's platted. You've got Beach Avenue down here. You've got Park Place here. And then you've got the lots further upland. Now, this plat includes the setbacks. And it depicts the setbacks on the plat, the 35-foot and the 10-foot, all the way around. When the Palisanos bought their property, they bought it, I mean, not the Palisanos, the Roberts bought their property. They bought it expressly subject to the subdivision plat and the deeds. It's contained in their deed. They have to follow the setbacks in the subdivision plat. So they were on notice from the very beginning of what the setbacks were, where they could build. Now, I want to fast forward to April of '22. That's when the first set of plans was submitted, and that's when the city first reviewed those plans. And let's see. We got comments from the city to the plans. And there was an email sent. I think we looked at this email earlier, but it says, see comments within uploaded document named Site Plan Markup, and we'll look at that here. But it also says, please provide a document with all structures overlaid onto the survey/recorded plat. Survey/recorded plat is important because those are different from a site plan. A surveyor recorded plat are created by a surveyor. Also, of note, all structures will need to be within required setback. And it says again, 35 front, 35 rear, side 10 foot. So here, if y'all can see this, this is the comments. It says the dimension is to the property line. The house as proposed is at the property line and does not consider the 35-foot setback. And so in May of '13, after reviewing the first set of plans, the city expressly tells Roberts, that the house is encroaching on the setbacks. It's not, it can't be built there. And so in response, Robert submits a revised site plan. Remember, it's not a survey and it's not a subdivision plat like what was asked for. But with this, you can see that instead of moving the house on the plan, they just changed the lots. There's no longer a lot 4B. They just took 4B off. They made lot 4A, and then they've measured 35 feet back into Beach Avenue. Down here, they measure the 35 feet from down by the water. And actually, I don't even think, based on that, that it's being measured from the water. So that's what was submitted. And, you know, it's not the city's obligation or responsibility or ability to catch erroneous documents that are submitted to the city. They rely on what was submitted to them. For somebody who's not a surveyor or a lawyer, this thing kind of purports to be a survey. It's got a stamp. That's an engineer or architect stamp. It's not a surveyor stamp. And so the city obviously relied on that and issued a set of plans. But then we move forward. That was in July. So now we move forward, and this is one of the most telling parts of this story. There was another opportunity for this problem to be discovered and for the house to be built where it belonged. And that is right here. Gotcha. So I want to look at this email exchange. And this starts on November 14th of 2022. And it starts after a call from the Roberts builder to Seth Moore, the surveyor. And Seth responds, he says, "Good to talk with you today. Please send me the floor plans and the plot plan." He's going to lay out the house on the lot, on a survey, or on the either a survey or the subdivision plat, the way it was supposed to be done months ago. 2 days later, November 17th, and this is some scheduling stuff I'm scrolling through, you get another email, and it's dated November 17th of 2022 at 4:16. The builder says, "Mr. Seth, are you available tomorrow morning? I will have my guys headed this way to lay out footprint for owners and architect meeting tomorrow about lunchtime." Owners and architect meeting. That was at 4:16 that afternoon. At 4:20, Seth responds in all bold caps, or all caps, "Have they addressed the layout problem?" November 17th of 22, no construction's been done at this point. There's a layout problem, and the owners know about it.
Were those emails to the owner?
This was an email between Seth Moore and the builder. He referenced an owner's meeting. And so what I'm about to get to is the very next day, on November 18th, my client, Carrie Palisano, receives a text message from Roberts, Mr. Roberts, asking about the old structure. November 18th of 22. And he's asking about the old house, old surveys, that sort of thing. Keep in mind, there's no house there now, but he's asking about the old one. I survey, and she's trying to help him find the old house or survey. She doesn't understand that there's a problem with the setbacks, but the fact that this text message is being sent the very next day indicates that Mr. Roberts understands there's a problem with the setbacks. And so, right about that same time frame, Mr. Moore creates a drawing. I say it's a drawing because it doesn't have a fieldwork date, but this image, this drawing, indicates where the house could be built within all of the setbacks. This drawing shows the setbacks on the plat the way it was originally asked for, shows the whole house, including the porch, within those setbacks. And so that's really the ultimate, that's all you need to make your decision, because if the house, as they planned it, can be built within all the setbacks, then you can't grant a variance. That's it. But we keep moving on from there because we've had an opportunity to get on the right track. And, defending the city to some extent, the city gave every opportunity. The city told them once in May, you're not within the setbacks. They sent back the erroneous site plan instead of the survey they were asked for. And then somehow the Roberts discovered again, that's when we had all this communication in November, another opportunity to discover it. And then here we go, there's another review of plans that occurs in December. And the city sends the plans with comments. And one of those comments, this is just an excerpt from that, is, again, provide survey to block or foam board prior to pouring concrete to verify setbacks and required finished floor elevation. Survey must be received and approved before permission to pour will be given. So that's, again, another review in December. Now, and here, again, how did this happen, okay? And we don't have all the pieces, but we know that something improper happened here, because on January 18th of 2023, this was the foundation inspection, the first foundation inspection. And the city meets, and they've got several comments. One, construction does not match engineer plan, but again, as to the survey, provide survey to verify as-built proper setbacks. That was January 18th of 23. The very next day, the inspection passes with comments. And the comments are upload survey to CitizenServe. That's January of 23. Now, that survey was never uploaded to CitizenServe. To this day, we have no idea what was shown to the inspector. And I haven't talked to the inspector, but it wasn't uploaded to CitizenServe. But what we know is it had to be erroneous, because if an accurate survey was shown to the inspector on the 19th that he told him to upload, then it would have been false, because the house was built outside of the setbacks. So, there's some talk about self-inflicted, and I really don't want to, I'm talking about this because I need to have y'all understand the full picture after the presentation that you were just given. Self-inflicted is not the only test for a variance. They don't qualify for a variance to begin with. We see the building could have been constructed on the lot within the setbacks. But to the extent self-inflicted is important, and here, any hardship, if there is any, was self-inflicted. And it doesn't really matter. We showed you that Mr. Roberts probably knew about it, but even if it was his agents, showing an erroneous survey in January of '23, it's self-inflicted. So, moving forward from that point, and again, this is going back to the self-inflicted and the we self-reported part that you just heard, okay? We fast forward from January of '23 to January of '25 when the violation is discovered, okay? This survey is discovered. I've talked to my clients, and construction kicked into high gear after the encroachment was discovered. And there were 2 hearings with the Board of Adjustment that were tabled while construction was still ongoing. And construction didn't ultimately stop until the stop work order was sent. And so there is certainly a self-inflicted component here, but don't lose track of the fact that none of the requirements for a variance are met here. That's how we got here. I want to add a little bit because I've got a little different view on the staff report as to that 4th component for a variance, and that is relief, if granted, would not cause substantial detriment to the public good or impair the purpose and intent of this ordinance. We've got setbacks in the zoning ordinance. I don't know that everybody always thinks about what they're for, but there's a reason they're in the zoning ordinance, and they've got lots of important purposes. And so as I was thinking through this, what are those purposes? Well, they protect owner expectations. Owners need to know where their neighbors can build, where new people can build. And I'm going to sidetrack for just a minute there, because where other houses are located has no bearing on whether they're entitled to a variance here, okay? It has no bearing. Those other houses could have been built before an amendment in the zoning ordinance. They could have been built in violation, who knows? But Mr. Roberts knew the setbacks when he bought that property. They were in the plat, they were in the deed. And while I'm talking about that and the others, I haven't seen that survey. I just asked, because I don't know anything about it, I'd ask you to judge that very critically, because a lot of things you can build some things in the setback. You can build walls, you can build fences, you can build, brick patios, that sort of thing. And so they may not necessarily be violating the setbacks by having something on the ground in the setbacks. And for instance, I understand, and we talked about it with my clients, we believe that we don't have anything in the setback. My client did a substantial remodel on their house. I can't remember the year, but they made it a point to comply with all the setbacks. They did. And whenever somebody buys or builds on that lot that they own, the Clover LLC lot, they're going to comply with the setbacks too. They're going to have to. And so getting back to the purpose of the setbacks, owners need to know where their neighbors can build. Setbacks over time create uniformity and aesthetic appeal. And the whole purpose of the non-conforming provisions that Hunter was talking about earlier, they're non-conformities. They're allowed to exist then, but they can't be perpetuated. They can't be created in the future. And over time, your zoning ordinance will have that effect of weeding out the nonconformities. And for instance, when that first house was torn down here, and another house gets built, that's how the zoning ordinance works to weed out the nonconformities. Setbacks they provide for privacy, they protect property values, they protect against spread of fire. I mean, my clients have they've got the side setback to the Clover where there's no structure yet, but that side setback's about protecting against fire, one of the things. But I think most importantly here, the purpose of the setbacks is they provide green space, okay? And there was a park platted here. Everybody has always known about the park when they bought their property there. For my clients, that was a tremendous appeal to why they bought that property. It was very appealing to them. If y'all have ever been out there, it's unique. You walk out there and it's just wide open. There's no fences. So you've got the green space of the park, but if you encroach into that setback, you're working to the detriment of the green space and the appeal of the park. And so on that fourth factor, we say that if the requested variance is granted, all of these reasons for a setback are going to be ignored. And granting the variance would cause substantial detriment to the public good and impair the purpose and intent of the ordinance. Thank you.
Anybody else from the public that would like to speak for or against?
Thank you, Board, for the opportunity. My name's Robert Brown. I came on, Bobby called in October and said, I need help. Builder had gone bankrupt, left him with shambles of a house. I went down there, looked at it, and probably about a month after, I'm looking at the site, and that's when I realized the house was skewed on the property line to the south. And we started investigating, and we found it was over the west setback as well. I said, Bobby, go to the city. We got to figure this out before we continue. So that's when he got the survey, and it showed the house 20 feet over the setback. The hardship, in my opinion, happened when the foundation survey was not uploaded. The city asked for a foundation survey for a reason, to catch it at the foundation level, not when the house is sheetrocked, trim, interior doors, cabinets going in. If this would have been caught at the inspection and the survey was uploaded, they said, you're not conforming, and a stop work order would have been put in when the foundation was in, not when the house is almost finished. So that, in my opinion, whoever gave the approved on the foundation without the survey being uploaded, that's where the error was. And I would challenge all of you to find anybody that's had more of a hardship than the Roberts in building a house. I've been doing this 25 years, and it's a shame. So, as you've seen, all the aerials, where the houses line up on the street, also the error was made when the 35-foot setback was put on these two lots. Thank you.
Mr. Chairman, may I answer just a couple of comments, please, before others have a chance to speak? First of all, Mr. Moore conducted this survey, and this is absolutely structure in setback. It's not uncovered patio. It's not, for example, one neighbor has a basketball court in the park, that the concrete slab is still there. This is actual constructed edge of house where you appropriately measure setback. Seth Moore knows how to do that, and that's exactly what this shows. And I thought it was, I also resent any implication that Mr. Roberts knew anything. He's not a contractor, he's not a surveyor, he's hired people to do that. He had no idea. And I resent any implication that he had some idea that this had happened. Finally, I find it interesting that one of the things he mentioned about setbacks and why we have them is uniformity. And I fail to see how making one house be 25 feet behind their neighbor promotes uniformity. I don't think it does at all. And we presented evidence to satisfy every single one of the four elements to you. So you've got all the information you need to make a decision in favor of a variance. And also, even more importantly, the state statute, which doesn't even list those four elements, and they didn't reference the state statute. But you are well within your right, based on what's been presented today, to rule in favor of this variance. I think there are some other folks who want to talk, but I appreciate the opportunity.
Can I ask him a question? Where's the basketball court?
Come up to the front and state
Oh,
your
that's
name.
good, that's embarrassing. I'll let him go.
Tyler and Jenna Parr. I spent a lot of time in this park. I know every inch of it. I would love to know where this basketball court is.
It's in front of my house. The basketball goal has been taken down. It's been there 50 years.
Eric, will you come up to the microphone, please?
There's a slab out there.
Mr. Chairman, to answer the question about the basketball goal, further to the south on North Mobile Street, a couple of years ago, we found that it was a concrete slab and a basketball goal. There was also a fence from the neighbor that were over onto the parkland. I ordered the neighbor to remove the fence. I told the person with the basketball goal, get rid of the hoop. I'm not necessarily going to make you take the slab out, but get rid of the hoop, and they both came into compliance. So it was gone as of a couple of years ago, just so you know.
Anybody else from the front would like to speak? Anybody else from the public that would like to speak for or against it?
Letters.
I'm just going to pull up the original slides if you need them, or if y'all have any questions for us, we'll certainly be able to answer those. But just for reference, I'll pull up the motions.
Before you close the public hearing, I would just offer 4 additional letters, one from my clients, Richard and Carrie Palisano, one from David Tang, one from Jean and Joanne Broadus, and another from Doctors Scott and Elizabeth Minto. And those are, I believe they're all in opposition.
Those are in your package.
These 4 are
Not seen those.
No,
No, I have not seen those.
one was.
I believe we did have.
Had some from the tarts, 2 from the tarts, but I didn't see those.
Tartan, yeah, Tartan Tang, so 3 new ones for your packet if you'll want to.
For the record, will you read those to the record for us, please?
Hunter?
How long do you want to be here? I believe it was,
Hunter, I sent an email to Lisa also, but no one sent me a formal letter. So even though I'm right across the street.
okay,
I just said that opposition letter.
okay. When, we'll get clarification on that. I can certainly summarize, glancing over, and I think Mr. Thetford said they're both in opposition. From Richard and Carrie Palisano, they own the lot just to the south. From David Tang at 619 North Mobile.
Opposition?
Opposition. If anyone's here, and I'm not reading all of this, but if I mistake, whether it's pro or con or opposition or in favor, let me know. We do have Jean and Joanne Broadus. I do not have an address on that one, if anybody does. Yes, ma'am.
I'd like to say something.
Okay. Oh, can you let me finish reading these real quick? There's the address.
617 North Mobile Street.
617 North Mobile Street. And then we also have Scott and Elizabeth Minto at 553 North Mobile Street. So I'll read those into record, but certainly,
Ross, will you state your name in the record for us?
Good evening, I'm Joanne Broadus. I live at 617 North Mobile Street, have lived there since 1992. I am well aware of the park, well aware. When we first moved, the house that we live in was built before we bought it already built. And it very much sets back. And I have observed for 33 years people trying to violate the setback. And it just is disturbing to me. Now, you mentioned that basketball court. When we first moved there, the neighbor that lived there had small children, and he did have a basketball court. But the people that live there right now do not use the concrete slab. We live there. We've been very active in the community for decades. I do the Dogwood Trail program and have worked with young people, and we have parties in the park. The girls love the park, and that is what it is. And we do not want anybody violating the setbacks. And when especially knowingly, and it seems like listening to the representatives that I don't know who's at fault here, and I don't understand all the legalese, but there certainly is a violation of the setback. You don't even need to even know that. All you do is go out on your back porch and you see this structure way out in the park. And it does violate our views of the bay, and that's why we live there. It is a unique, beautiful place, and we have to maintain the setbacks for all of us, because all of us neighbors, we love where we live. And I am personally very disturbed about the idea that, and I don't know who's at fault here, but it seems like there's several areas that could be considered about who is at fault. And it is going to be a hardship to try to resolve the problem, but it needs to be resolved. Thank you very much for your time.
Before we close the public portion? The public portion is now closed. Board members, do we have any more discussion, and do we have a motion?
A question. I don't know if this is even relevant. This is Lot 4A. Who owns Lot 4B? Was it sold at one time? It's a separate lot?
Sure. And that's why we kind of added some appendices here. To explain, let's see, let's go to this one. And sorry, this is a lot of land, so if we need to zoom in here, we might need to kind of tweak some things. So I think you saw the original plats from 1914. So we're talking properties that go way back in time. And as you also saw, the lot down there at the bay was really, it's a little subjective of what that was intended for when they laid this out. There was a beach, there was parkland, there was right-of-way, and then there's beach. And along the bay, there's different places. There's a Magnolia Beach subdivision. There's different ones, but it wasn't individual lots. It was one large lot. Through years, and those were kind of deeded, not really subdivided into lots, but it became so that the folks at the top of the bluff had a little bayfront down at the bay, and those were deeded. When the Palisanos came in and discussed with us, and again, I want to mention the zoning ordinance is iterative. There's amendments. 2005, there was a big amendment that adopted a new ordinance. Even since then, 20 amendments maybe that have kind of changed the zoning ordinance. One of those added a definition for bayfront lots and then tweaked that at times. One of those changed how we measure setbacks when there's nonconformities. So each of those iterative processes create kind of new rules as something new gets built. When the Palisanos came in, and I don't want to paraphrase too much here because it's been 5 years ago, but there was conversation of wanting to build like a bayfront lot. But as you heard, the lots here, it was a separate lot. And there's something unique about that parkland. Some of the lots that come in are separated by right-of-way. There's something called a land hook in taxation that they can link to separate parcels separated by a right-of-way and give them the same parcel number, PIN number, whatever you want to call it. They're equivalently the same lot. That's not the case with parkland. The tax revenue would not do that. Land hook had to be separate PIN numbers, separate lots. So by definition, In the zoning ordinance, that lot at the top of the bluff is not a waterfront lot. It does not abut water. So the goal there was to be able to use that as a waterfront lot. And what we came up with an agreement, it's not clear when the zoning ordinance, there is a uniqueness by the park and the right-of-way both being separated. By being able to combine, by a condition on here, there's a condition that's in small text that says lots 4A and 4B will be conveyed together into perpetuity.
Okay.
It's not the same lot. But what we agreed to, and by the Palisanos saying this is a setbacks. Lot 4B is, I don't even know, we had a couple of options there, and one would have taken a long time. Get me long research of what that lot is down there. Is it really even a lot? Is it waters of the state? There's some clarity on what happens there, mean high tide, all this. I couldn't guarantee what the width of that 4B lot was. So the goal was not to build anything down there anyway. Maybe a permit through the waters of the state lands or to build a pier. But the goal was to build on the upper part of the lot. So the setbacks were established in cooperations with the property owner. That was an interpretation of this particular piece in our zoning ordinance to meet that goal. So lots 4A and 4B will convey indefinitely, and lots 5A and 5B will convey indefinitely. They are treated as one that are separated by something that legally we can't call it the same lot, but we're getting that same effect.
Thank
was
you.
the goal. Okay.
Were there any changes to the construction documents, the architecture, as far as, there's no steps on the house now, right? On the front part. That's not even included on the setback?
No, and steps are typically not in our zoning ordinance. Uncovered, steps, we allow those to be in setbacks. That's, we might challenge that if somebody comes in and says we want 35-foot wide steps and, that's the whole width of the lot. But that's usually not something, as long as it's uncovered, is allowed to be within the setback.
So they could still go out however many feet with the steps in
Yes.
addition to the 20 asking for?
That's correct. And I was kind of just, yes. That would be correct as long as it's uncovered.
Are we considering these separate with the walkway? Because if it's not framed, it's legal? And are we just then considering the rest of it?
There's fortunately metrics there that you can apply to this. The applicant certainly has the right to request both and could have if granted, could have a covered walkway. I think I heard Mr. Roberts said that's not a problem, so to leave it uncovered, but if that was not granted, in that case, it's no problem denying that request. And then you can kind of, if it makes you feel comfortable and you want to vote individually or put it in the motion of what you're granting a front setback and a side setback variance. Unfortunately, there's a little bit of a matrix where I think I forget the math, but about 16 options or 8 different options that could be done, that could be approved or denied. Does that help?
Yeah, thank you.
Okay.
I'll do it. Mr. Chairman, I make a motion to deny both the front and the side setback, BOA 25.05.
Second.
Roll call vote. Stop. Donna?
Aye.
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 Motion Motion is denied unanimously. Is there any other new or old business that we will have? Or do we have a meeting for next month?
We plan on it. We do have applications. We haven't finalized the agenda yet.
Have a motion to adjourn?
So moved.